Hello and welcome to Defense Diaries. I'm your host, Bob Mata, and I am joined once again by my beautiful and brilliant co host who's currently playing with her hair. What's up, girl?
Hi, babe. Hi, all. I just got out of the shower, so I was trying not to get it all flat with these headphones. But
Looking clean. Looking clean. So, got a big couple of days in the Karen Reed case over the next two, depending on how much they get done tomorrow. So, they've got a couple of days set aside for all of the pending motions in limine, and it should be a raucous affair. There's a lot going on. I'm a little bit surprised there wasn't more filed today. Today has I thought today had all the hallmarks of a huge document dump day because I think it was the filing deadline because the next couple of days are really the last, pretrial motion days. So I guess it is what it is. So we've got a few to go through and they're relatively interesting. They're relatively interesting. We've got I'm just going to kind of name them and tell you what we're going to go through. We're going to go through the Commonwealth's opposition to quote the defendant's motion in limine to allow evidence of lack of bias, which obviously relates to the fact that they want to be able to um,
identify
clearly
ARCCA as being hired by
right, the
federal agents.
DOJ, right?
Right.
And then we've got another one that is regarding the buffer zone. It's a buffer zone one. Commonwealth's motion for buffer zone and order prohibiting signs or clothing in favor of either party or law enforcement. I mean, she had the buffer zone the first time. Everybody thought it was unconstitutional. She'll probably do it again. It's interesting because usually it's the defendant that is complaining about things that are going on outside of the courtroom. That's just another one of the interesting things about the Karen Reed case. It's quite
Right.
the
And
opposite.
at least in, Massachusetts, they're going to have to follow that. They can't set one rule when, it's all a bunch of pro defense people out there. So they'll have to be prepared to follow that when it's just a bunch of people screaming and yelling to hang somebody.
Right. Exactly. And then there's got a couple of shorties, defendant's motion to impound exhibit 1 in support of defendant's motion to eliminate to exclude the testimony of Commonwealth's witness, Dr. Judson Welcher.
I didn't see the actual motion to exclude. I just saw to impound an exhibit. Is the motion there too?
Yeah, they had argued that the last time we were in. Like that was the one where,
Oh, so they were following like a late exhibit?
yeah, Leslie was like, this guy is, he doesn't have a methodology. This guy's from Clown Town, like so.
I have to say, the level of motion in limine practice that's occurring in this case is insane. Like
It's a
I
lot.
feel like the judge is going to be like, "What in the hell is wrong with you people? All of you. I need a week to deal with your motions in limine."
Yeah, I mean it's a lot. And then the Commonwealth's motion to eliminate to exclude defense expert Michael Easter's opinion of the investigation. And then finally there's the motion to eliminate to exclude expert testimony of Mr. Garrett Wing.
I have a question. Is Michael Easter's, is that his name? Do we have his CV? Because there are, if you've got some experience and you've been, can be an expert in police practices, what's procedure, things like that. I mean, it's been done before, but I mean, I guess I'll wait till we get to that. Let people stroll in here. And happy St. Patrick's Day.
Yeah, happy
Oh
St.
no, I don't
Patrick's
like
Day,
those little
beautiful people. That's
circles.
why I'm wearing my green. My green because it's St. Patty's
What's
Day.
with the circles?
What circles?
We're in circles.
Oh, I don't know. I blame you. There we go.
Here we go.
There we go. You don't like the circles? You're not a fan of the circle? Not a fan of the circle. All right, so let's start digging in Let's start with the Garrett
Yeah.
Wing. What was that?
It's just me for a second.
Oh, okay. Let's start with Garrett Wing, the Garrett Wing motion.
Well, before we get to the Garrett Wing motion, are you going to do that afterwards?
What? No. Come on,
Okay.
you're
All
ruining my
right. All
bit.
right. I'll let you.
What a spoiler that just
Let's-
was.
No one knows
Wow.
what I was saying.
Wow. Allie's that one of those folks that like she gets a really good gift for you. Like, and she buys it like a week before your birthday or something. She's like, hey, do you want your gift? I'm like, wait, my birthday's in a week. She's like, so what? She's like, do you want your gift? It's awesome. And I'm like, well, I mean, what will I open on my birthday? She's like, who cares?
Why does your screen look so mini? Is it
Mini?
maybe like pulled down on your,
What do you mean?
like,
Which
is it
screen?
low in the screen that you're sharing? It's like it's missing like the top and the bottom. It's usually bigger.
I don't think it is. I mean, it's fully it's full screen.
Okay.
I think that's the size it normally is. Currently sharing.
Well, I'm looking in the box that's dedicated for that screen, and it's a lot.
I could try. Let me see what this does. I don't know. I'm afraid. Oh,
Oh.
hey.
Oh,
Hi.
oh. What the hell was that?
I don't know. It was in there was a thing on like a Google Chrome thing with like
A camera to a
person.
camera.
Wow. Look at that.
What?
Wow.
Wait, how come we don't even see you doing that while you're sitting there?
I don't know. It's weird. It's crazy. All I can tell you is I'm a tech wizard. That's all I know. That's all I can say about it.
Oh God.
All right, so let's plow through this one. It's very short, very brief. And we will, as always, alternate reading. So I'll read this one. Commonwealth's motion eliminate to exclude expert testimony of Garrett Wing. Now comes the Commonwealth in the above caption matter and respectfully request this honorable court exclude expert testimony based on a violation of Rule 14 notice. So Mass Criminal Procedure Rule 14 specifies that expert opinion evidence includes, quote, the identity, I feel like there's a lot of moving going around.
I think Mandy's trying different things.
Current curriculum vitae. All right, we're gonna get a kill it. We're gonna get a strike for that. I can't play any shipping off to Boston at all. As much as I want to. Like, I would frankly have bagpipes. I don't know. Like, did I put it on there? I probably put it on there. I think it's under the 3 seconds. She's like, why is it on there then?
Right? Why give us stuff we can't use? Jesus, Bob.
You know, it's like I want to
I
buck the
still
system.
can't get over why your screen looks so little.
It always looks like this.
Okay.
Always. Like, it always looks like that. Wow. There you go. Oh, is that bigger?
It's just
See?
me.
If it's just you, it's bigger.
No, it's not.
Yes, it is.
Oh.
See? Smaller.
Oh.
Smaller. Bigger. Oh,
Oh.
is that bigger?
All right, let's get to it. Sorry.
let's
I'll
get to
stop.
it. I mean, I think it's the same size, girl. All right. So specifies that expert evidence includes, quote, the identity, curriculum vitae, or current CV, and a list of the publications of each intended expert witness, and all reports prepared by the expert that pertain to the case. Here, the defendant failed to provide the Commonwealth with any report or with any basis for any opinion it intends to offer at trial. In regard to the named expert, Wing, all the Commonwealth has been provided with is a CV. The Commonwealth has no information as to the substance of Wing's testimony or any opinion he may render. Now, I'm about to help you out here, Hank. About to help you out right now, dude. I'm going to help you immediately. I hope that you're watching, Hank, because this will be very, very helpful for you. And I think that it will go a long way to describing what this guy's getting on to testify about.
Yes, the more and more I look at it, the more and more I'm convinced. You know, I would bet money that this is a dog bite.
All right, so pause it real quick.
That's his
So-
opinion, Hank.
Those of you that don't know, that is our friend and beautiful attorney Melanie Little. She had this expert on her show over a year ago, I think it was.
Yeah, like a
Um,
year ago.
And he did a very thorough explanation as to why he thinks that those are dog bites. And we did get her approval to play this for you
Let me
guys.
ask you a question on the show.
Yeah, we always ask opinions. So, Allie's like, wait, the defense guy, she's texting Melanie. They got the expert opinion from your live like a year ago, not like recently. So it was before the first trial. It was before the first trial.
You know about it now.
They know about it now. Now they know.
Now they know.
We can expect to hear the fact that, like, I anticipate that Hank will say something snarky about how now the defense is resorting to using experts off YouTube channels.
The guy has told me he has established YouTube himself with over 2 million subscribers. So
who?
Wing.
Garrett?
Yeah.
Are
you gonna play a little bit of his opinion here?
Yeah, I just did. You said I'd bet anything. It was a dog bite. I mean, what else do we need to hear?
On this picture on the right here, it looks to what looks to be a giant bump on his right bicep above the first two lacerations, I'm going to call them. Can a dog dislocate a person's shoulder by latching on like that? I saw one of your videos where you said, and the dog actually came after you with one of those, what do you call the protective device that you wear on your right arm when you're training?
Sleeve.
Yeah, and you said, it feels like I dislocated my shoulder. I'm just wondering if that is something that could happen, because I don't know I'm not a medical examiner.
It would have to be an extremely well-trained dog that is very powerful to bite and hold, and then in combination with a handler using 200 pounds of their own body weight.
Part that doesn't matter because he doesn't have a dislocated shoulder, right?
The dog.
I mean, what is that?
When could this happen? Let's say a suspect hiding in a closet refusing to come out. We've seen that happen. They're in a car. They're like seat belted in. I've been in situations like that. That dog has got a really good grip.
This is obviously before the medical examiner's report comes out. This is, like I said, a year ago. Or over a year ago at this point, maybe. I don't know.
This live is from over a year ago. It was before the trial.
Well, obviously, yeah.
I think I don't know where the hell they put the date. Probably somewhere in the. It's funny. I don't know that. Where do they show the date on here? I don't know. Oh, wait, maybe here.
January 12th.
Oh, you saw it?
2024.
Yeah. Somebody in the chat.
The very top.
Oh, thanks, babe. So good. So good. Good and kind.
And we use the 80, 90, 100 pounds worth of dog, the 200 pounds plus of me. And
did anybody bring up that weird bump there during the trial?
I don't know. I'll text Mel. Did we ever find out what that weird bump is you were talking about?
Yeah, what is that weird bump? It's a strange bump. Strange. All right, here we're gonna get back to the docs. So that's who Garrett Wing is, in case y'all didn't know. And I'm putting it on the record tonight. I'm betting that Hank Brennan, like, very snarkily says, "Oh, now the defense is resorting something to the nature that the defense is getting their experts off Karen Reed supporter LawTube YouTube channels, some shit like that." He'll say, because Hank, he just likes to say shit. So,
and if you haven't already subscribed, become a cupcake. Subscribe to Attorney Melanie Little.
Be a cupcake. Everybody be a cupcake. All right, let me pull this up.
And by the way, Melanie said no. I've never gotten an explanation for what that is and why his shoulder looks like that.
Momo Shark says bad tetanus reaction. I just got a tetanus shot a couple weeks ago. I had no reaction like that. Knock on wood. I think I'm on it, like, in the clear. In the clear. So in regard to the above named expert Wing, all the Commonwealth has been provided is a CV. Commonwealth has no information as the substance of Wing's testimony or any opinion he may render. Now you do. You're welcome, Hank. You're welcome. Without a report provided, the Commonwealth is entirely unable to prepare for any suggested testimony of Wing and would not have sufficient time to provide any rebuttal evidence unless I go on the YouTubes. As the Commonwealth is not expected to proceed with trial by ambush, the Commonwealth asks this honorable court to exclude the testimony of this alleged expert. He is such a... in the alternative, the Commonwealth moves to compel the defendant to provide the Commonwealth with the subject matter of his testimony, reports, and notes prepared by such an expert and the expert's opinion and the basis for the expert's opinion.
So I suspect that she will, if they really haven't provided any more detail, she will make them. Last time they said they didn't get provided any more detail. They indicated what they provided him with, and that was in compliance with the rules. So we shall see.
We shall see. That'll be one of the first ones argued because it's quick and painless. Did you stop the screen?
Oh, I
Yeah.
thought you were going to pull up the
No,
next.
I can just kind of whip through them because they're all up.
Oh.
Like, boop. See? All right, you ready to do some reading?
Yeah. I got to
That
blow
did
it up.
not sound.
No, it's all right. I just had to blow it up. The Commonwealth moves to exclude. All right. So this is their motion to exclude defense expert Michael Easter's opinion of the investigation. The Commonwealth moves to exclude the proposed personal opinion of Michael Easter, a retired special agent for the Federal Bureau of Investigations, regarding alleged inadequacies in the investigation.
Do you want to go to the footnote?
Or you can just read it. Okay.
Yeah, to the Commonwealth's knowledge, Mr. Easter was not involved in the U.S. Attorney's Office for the District of Massachusetts investigation into the death of Mr. John O'Keefe.
The Commonwealth does not dispute that Mr. Easter is qualified to render an opinion regarding cell site and cell tower location information. However, Mr. Easter is not qualified to render his opinion about any alleged inadequacies in the police investigation. That is a determination left solely to the trier of fact. I disagree, but
I do as well.
And the law that he cites doesn't seem to say exactly that. But anyway, so he cites the touchstone of admissibility is reliability, and the defendant must establish 5 foundational requirements for admission. First, the expert witness's testimony will assist the trier of fact. Second, the witness is qualified in the relevant area. Third, the facts are sufficient to enable the witness to give an admissible opinion, that there is not mere speculation. Fourth, the expert opinion is based on reliable principle or methodology. And fifth, the expert opinion is reliably applied to the principles and methods to the facts of the case. And they cite the reporter's note in Massachusetts Rule of Evidence 702, which follows the federal rules of evidence and similar to most states as well. While the defendant has the right to base her defense on the, quote, failure of police adequately to investigate a murder in order to raise the issue of reasonable doubt as to defendant's guilt in the minds of the jury, this is achieved through cross-examination of the witness, not a different law enforcement officer to opine that he would have conducted the investigation differently. And he cites a 2006 case for the proposition that police reports detailing the incriminating words and conduct of another suspect would be admissible to show that the police were on notice of the suspect but failed to investigate his possible involvement in the murder. So I would just note that that proposition seems to stand for the exact opposite of what Brennan is saying right now. So I don't get it. He also cites Commonwealth v. Moore, a 2018 case. Relevant evidence means evidence having a tendency to make a consequence of fact more or less probable and to provide a link in the chain of proof. Mr. Easter's opinions are premised upon unspecified, quote, discovery material provided by the Commonwealth from an electronic folder produced to him by Attorney Jackson. The entirety of what he reviewed or did not review was not disclosed to the Commonwealth. Mr. Easter's opinions contrasting, quote, best practices are devoid of any real-world considerations, such as weather. Okay.
The weather.
The weather. and without consideration of the physical evidence, the defendant's many statements, the vehicle data, the fact that the witnesses have testified under oath in many situations 3 times, and an understanding of that it was a grand jury of citizens who charged and indicted the defendant. What in the hell is Brennan going on about right now? He's
I have
just
no
like
idea.
whining about nothing.
That's what he does. He just says shit.
Further,
I mean, I've said that a million times. Like, this guy literally just walks into the courtroom and says shit. He's got no basis in the law. He supplies no real evidence, puts no witnesses on. He just comes in and whines and says shit.
well, it
That's
gets
his move.
worse. So let's move on.
Let's go.
Further, while qualified to render an opinion of this CSLI location information, which is already what the L is and the I, there is no inclination that Mr. Easter has the training and experience in investigating homicides, particularly in the first few critical days of an investigation. Notably, quote, the conduct of a police officer, that of a reasonable officer on the scene, acknowledging that the officer may be forced to make split-second judgment in certain difficult circumstances, prevent the court from engaging in unrealistic second guessing of police officers' decisions. This is a completely factually different scenario, as we're going to see from the next site, which is a different federal case, but he says stands for the same proposition. In allegations of excessive force, expert testimony was irrelevant and unfairly prejudicial, where, and this is key, and he quotes it, the fact that someone with the opportunity to prepare an expert report at leisure opines that well-trained officers would have performed differently under pressure. That's not the facts we are presented with. We're not talking about a split-second decision that a law enforcement officer had to make, and then someone coming down and trying to say, well, he could have done this, he couldn't have done that.
No,
Obviously,
we're talking about them saying they use red Solo cups in a leaf blower. It's not standard protocol. I mean,
and that they failed to investigate all avenues of available investigation,
correct.
i.e., other potential suspects.
Yeah.
Mr. Easter's report also seems to suggest, now this is freaking bizarre to me, all right? Mr. Easter's report also seems to suggest that the defense is attempting to backdoor third-party culprit into a Bowdoin defense. They are definitely intertwined. The whole point of the Bowdoin defense is to say you had notice of this other possible suspect, and then you did not investigate them. So there's no backdooring here, Brennan.
Front door. Going in
Right through the front door.
Front door.
While often confused with each other, third-party culprit and Bowdoin defenses are logically and legally different. Thanks, Brennan, for mansplaining for us all. Third-party culprit evidence is used to suggest that someone else committed the crime. So-called Bowdoin evidence is to suggest that, quote, the evidence at trial may be inadequate or unreliable because the police failed to conduct scientific tests or to pursue leads that a reasonable police office investigation would have conducted or investigated. And these tests or investigation reasonably may have led to significant evidence of the defendant's guilt or innocence. So I'm sorry, sir. How is that backdooring? Where's the back door? Front door. Evidence admitted pursuant to a Bowdoin defense is not hearsay because it is not offered to show the truth of the matter asserted. Thanks for that fact that doesn't matter.
Factoid.
Just going to drop in this like random fact here in case you wanted to know. If the
Factoid.
defendant intends to offer evidence that police officers knew of an alternate suspect and failed to take reasonable steps to investigate, the information may be admitted simply to show that information was provided to police and not adequately investigated. However, this does not mean that defense counsel may always be able to admit third-party culprit evidence as a part of a Bowdoin defense, even when it would otherwise not be admissible under a third-party culprit defense. Okay, sir. So all the times that it's not always allowed, those are the times it is allowed. Right, babe?
That is correct, my dear.
In contrast to third-party culprit defense, where evidence may be admitted regardless of whether the police had got a stroll.
Oop, sorry.
Knew of the suspect, third-party culprit information is admissible under Bowdoin defense only if the police had learned of it during the investigation and failed to reasonably act on the information. Yeah, like you mean the facts they're talking about here?
Front door.
Furthermore, unlike third-party culprit evidence, there's no constitutional right to present a Bowdoin defense. And your point, sir? The defense's speculative claims, bolstered only by unreliable innuendos or a difference of opinion that serves to criticize 3 years after the fact investigative steps taken by law enforcement, do not rise to sufficient probable weight that exceeds the risk of unfair prejudice to the Commonwealth and would confuse the jury by diverting their attention to collateral matters. Where's all your case law that cites to that proposition? Where is something that says that?
In Brennan's world, the defense can never put on a defense because you know what that might do? It might confuse the jury. Hey,
might prejudice the Commonwealth.
Shit that might have happened. I don't want you all to be confused, so we're going to look to keep it out completely. We're just going to put our theory forward because we don't want you to be confused.
No, and we wouldn't want to prejudice the Commonwealth. I mean, it's
they deserve a fair trial. Haven't
a
you heard,
defense is
y'all?
definitely prejudicial to the Commonwealth. How dare they? How dare they?
They just created a new amendment. The Sixth Amendment now applies to the state. Didn't y'all hear? Have you heard the good news? Yeah, that did not happen.
For the above stated reason, Mr. Easter should be excluded from testifying about perceived inadequacies of the investigation.
I could see her putting some kind of limitations.
I could too.
You know.
But not
that
it all
right.
depends.
I could just see her doing it.
I mean, but it all depends. I mean,
right.
But at least we know it's not hearsay.
I don't know if Brennan really just hasn't read the transcripts from the first trial, but they definitely, when they argued this prior to the first trial, Cannone's kind of middle ground was like, all right, I'm going to allow you to develop a Bowdoin through cross-examination during the state's
third-party culprit through it.
Through like Bowdoin shit.
No, Bowdoin's not third-party. Bowdoin's the investigation.
That's what I'm saying. She said that she was gonna if they developed enough through
Bowdoin,
hammering them on the Bowdoin shit, that she saw enough for them to go, but she just let it go. It went.
It went
from the get.
It went. I don't see her limiting the. I mean, who knows? She's gonna limit the third-party culprit stuff probably for sure, but this is not. This is not that. All right, now this one I'd love to see the law that he is cited on this.
Yeah. All right. So this is the Commonwealth's opposition to defendant's motion in limine to allow evidence of lack of bias.
Again, this is all about ARCCA was hired by the DOJ.
Right. And the defense wants that to be told to the jury.
Yep. Right. All of it. So. Let's tell the jury the truth.
Right. So just what the facts are.
Yeah, the facts.
It is what it is.
Yes.
Why is there ball hiding at all as to who hired
no more ball hiding.
Okay, so now comes the Commonwealth in the above caption matter and respectfully opposes the defendant's motion in limine to allow evidence of lack of bias. Contrary to the defense's repeated representations to this court and public and the first jury, the employees of ARCCA were and are not impartial nor unbiased.
Oh my gosh.
The Commonwealth has a good faith belief that the defense instigated the now closed, this guy, that is a serious accusation.
Well, no, that may very well be that they just reported information to the FBI.
No, they already had the Sandra Birchmore thing going on. That was happening. It's when they filed their motion to dismiss and it started to become news, the feds realized, look, this is same PD.
I do think that they said they sent some stuff to the feds, but that doesn't make the
I don't know that it was
investigation
ever
unbiased.
like I do
Or
you
biased.
remember one of the lawyers saying that? I remember a bunch of people saying that.
I
I don't
thought
remember.
so.
Let us know in the chat if you remember, because it would have been Yannetti.
I'm asking Melanie Little.
Yeah, ask Melanie, she'll know. So the Commonwealth has a good faith belief that the defense instigated the now closed federal investigation and actively participated in providing selective information and materials to the United States Attorney's Office to attempt to propel and shape the federal investigation. I mean, that is a serious accusation. It just is. You think the feds are just going to take a bunch of shit from some defense attorneys in a case?
Right.
And that's what they're
I
going
mean,
to base
that's the
their
point.
shit on?
Even if they did send information on,
Excuse me.
that does not, by any stretch of the imagination, amount to the words that he just spoke. He can't shape the federal investigation by providing information.
There's Brennan just saying shit again.
Yeah,
So
because I
first,
said
the
so.
extent of the murky relationship between the defense team and the past administration of the United States Attorney's Office is still unknown. Footnote
Wow.
1. Go ahead and read
Wow.
it, babe. Can you read it? If
Well,
you can, I can.
numerous TUI requests have not produced sufficient level of material information needed to identify the extent of the relationship between the defense and the U.S. Attorney's Office and what, if any, impact the relationship and source of materials may have upon the scope of ARCCA's directive and efforts. So here's what I'm going to say before you start reading again. What about every single expert, witness, law enforcement, lab, whatever, that the state puts on in every single case? Is he suggesting that there should be some sort of, I'd love it. Let's have a jury instruction that says by the mere fact that these are fellow law enforcement or fellow governmental agencies, you can take that as per se bias and when considering their opinions in this court of law. I mean, what is this? A freaking joke? This all of a sudden. So now, because look, when Bob and I are looking for experts, I always say my first choice is former law enforcement, former FBI, because I want to get the same level of extra credence that law enforcement get from the state's experts. It's a preposterous and if she, I really hope she doesn't latch onto this and act like this is really a thing, because it seems like she kind of wants to.
I look, she's not keeping right. Cannone is not keeping ARCCA out.
Oh no.
Right. So just like you guys out there, don't worry. ARCCA is going to be testifying. The question is the jury going to be advised as to who hired them? Because it matters. It matters. We heard it from Ronnie, the juror. It matters. Like they're wasting their time wondering who these guys are and who hired them. And it's not honest brokering in my book. Like the defense can't help that they went out and did their investigation and the shit just happened to come down on their side. That's it. I mean, it is what it is. Now, the question is, would the defense be arguing just as hard to try to keep their shit out if they had come down on the Commonwealth side? Maybe.
Yeah,
I don't know.
It's not like we as the defense bar have ever been able to keep out an expert opinion of the FBI,
right,
DAU, whatever it is, and say something to the effect of this is giving them too much credence. They're getting way, this is making them look way too good. What? Huh?
To this day, it is unclear how that relationship may have shaped or impacted ARCCA's efforts. The actual directive to ARCCA made by the past administration of the U.S. Attorney's Office and any shaping of ARCCA's efforts are not known. Why don't you call them, Pinhead?
FYI, Melanie said the same thing you did. She said, no, I don't think they had anything to do with it, but I can't confirm. I think they were already investigating Sandra Birchmore.
Right.
I don't know why I thought I heard something like that at some point, but
like just in the noise the
But even
noise
if
out
they
there.
did, I'm just saying that doesn't mean shit. Passing
Well,
along
I think
information.
Lally made the same kind of allegation. Like during when they were arguing this
And
first
so
time around. Right.
that's like saying someone reports a crime and then the police investigate that it's their outcome of that investigation was somehow what was the words that they used?
Who?
Whatever, what that Brennan used.
Shaping.
Yeah, it was somehow
Shaping.
shaped and
Shaping
brought
the
on by
investigation.
the person who reports the crime.
Molding, shaping and molding the investigation. I mean, look, whatever.
And is Josh H. right? There's no allegation, no affidavit per usual.
No, of course not. Don't be
No,
ridiculous.
he might have put a sworn affirmation at the end. We'll see.
It's not the same thing.
Mm.
It has been established that throughout the course of the federal investigation, the defense communicated with the U.S. Attorney's Office and provided material selected by the defense without any input by the Commonwealth, including related claims and information that advanced the defendant's theory of the case. A specific accounting of all materials provided to the ARCCA witnesses by the U.S. Attorney's Office are indeterminate. Much of the inculpatory materials available do not seem to have been provided to ARCCA witnesses before they conducted their testing and presented their report. Footnote 2. I'll read it.
No. I was gonna I just want to scream because it doesn't matter. They weren't investigating the crime. They were investigating whether the car touched the human.
Right.
Period.
That's it.
They don't need anything else.
Right. Well, I mean, that was the first step of their investigation. Like I'm talking about the DOJ.
Right.
First, they determine whether or not, like that investigation for them begins and ends the same way that this case does, and where it begins and ends for me. Was the man hit by the car?
Right. And are they
If the man wasn't hit
suggesting
by the car, we have nothing to investigate with Canton, or we do have a bunch to investigate because they just made a case when we know he wasn't hit by the car. So now they're in deep shit. You know what I mean? So so once they got Wolf and Rensselaer to say, in our opinion, this man was not struck by a vehicle, feds are like, all right, we need to get their phones. We're going to start digging in. That's the way this shit went down. I mean, that was the very first question they would have asked.
Right. I mean, he seems to be suggesting that the FBI is like, hey, could you go and determine that vehicle didn't hit that person? That's what I need you to go do. I need you to go out there and tell me that vehicle didn't touch that person.
All right, read that footnote. Footnote 2. Can you read it?
I blew it up. In its report, ARCCA witnesses did not appear to consider Mr. O'Keefe's DNA on the defendant's Lexus broken taillight casing, taillight shards from the defendant's broken taillight found in Mr. O'Keefe's clothing, text stream data, and numerous statements and admissions by the defendant to various sources. I just want to strangle him. That is the whole point. Let's say, Brennan, hypothetically, your law enforcement planted that stuff. Why would the experts need to rely on anything else other than the damage to the vehicle, the damage to the person?
Right.
Period.
What else do they need to see? Like what does any of that have to do with them trying to look at the biomechanics of this thing?
Right. Because if it's planted, then you're telling them to take into consideration planted evidence.
Did you hear the audio of Carriage saying, "I hit him"? Did I hit him? Did you hear that in coming to? What the fuck does it have to do with?
So now did you change your mind because someone said that Karen said? I mean, come on, just stop making ridiculous arguments. He's wasting everybody's time. Where's the law on whether on the basis upon which this court should exclude who they were hired from? Where is any response to that thus far?
I mean, wait till you get to. Did you look at the thing where he's trying? Well, wait till you see his response. I'm like, he's got 5 pages of giving us all a tutorial on Daubert Lanigan.
Oh my God, I did.
Mentions.
Yeah, we're skipping all of that when we get to that.
Skipping
motion.
all of it.
I was like, what?
Guys,
Okay, again with your, mansplaining.
Yeah, mansplaining of Daubert Lanigan. It's like, it's like your law school class. You're going in 5 pages of telling a judge what it is.
That has
instead of like just the general propositions and the
nominally relevant.
It's ridiculous. So ARCCA testified to information and materials that were not noticed in the report as materials reviewed. The uncertainty and lack of transparency is frustrated by the defense's continuous promotion, mischaracterizing the ARCCA reports and findings as part of a closed federal investigation. Second time he said that.
It was.
Like this dude, like everything that he filed today is an absolute work around the gag. Like he is just like every single motion is shitting on the defense, calling them slimy, calling him like everything that he's filed has been an absolute work around the gag.
We're
Just
not going to
shit
call
on
it
the
that
defense.
because it's what's good. We can't say that in one breath and not in another. So it's a legal pleading. Do what he wants.
So as part of the closed federal investigation, the U.S. Attorney's Office contracted with the ARCCA on February 12th of 2024, ARCCA generated a 13-page report of 4 specific findings. Those findings were not, as the defense claims, unequivocal evidence that the victim was not struck by a vehicle. Rather, the ARCCA findings were narrowly tailored to whether the ARCCA witnesses believed the injuries to Mr. O'Keefe produced damage as observed in photographs to the Lexus. So, in fact, the defendant's expert, Dr. Rensler, testified and acknowledged that, quote, if there is a sideswipe impact with a pedestrian in a bicycle or a pedestrian in a vehicle, there is going to be very little damage to the pedestrian. So a sideswipe by its very nature involves minimal impact, minimal forces, minimal velocities, end quote, which, contrary to the defendant's claim, advances the Commonwealth's theory of the case. Then use them.
What world is he living in? They still got Trooper Paul listed as one of their witnesses. The man was projected. He was.
Excuse me. After he pirouetted.
Right. I was just going to say. I was literally just about to add the pirouette.
Never forget the pirouette. Second, there is no adequate assurance that the ARCCA witnesses lack bias. The past opportunity to voir dire the ARCCA witnesses did not mitigate the lack of. Hey, go talk to your buddy Lally. Say, hey, Adam, why did you suck during that voir dire?
So what? She gives him another voir dire. Give him another voir dire, because I don't want that. I don't want him probing all that shit at trial. Make him shut up.
It did not mitigate the lack of transparency about the ARCCA defense relationship. The defense did not inform the Commonwealth about its substantive relationship with ARCCA until February 13th of 2025. Notably, the defense disclosures came one day after the new administration at the U.S. Attorney's Office produced, in response to the Commonwealth's TUI request, materials that included correspondence between it and the defense. No, it was turned over after you provided your certificate of completion. Like that was the only time it was due. When Brennan turned over his certificate of completion of discovery, next day they turned their shit over.
Yep.
Like him trying to frame it like this is so disingenuous and so scummy. Like this dude's like actually, like when I say that he like just discuss, he's a defense bar guy. This guy isn't he comes off like he's been a prosecutor like his entire life. Like this is the kind of shit that I'm used to, prosecutors.
He's like, I know how to play their games. I've seen them. I'm just going to say a bunch of shit, and then it's going to be believed because I'm, guess what?
The prosecutor.
Prosecutor.
All right. Okay. So before February 13th of 2025, the Commonwealth was wholly unaware of the defense's relationship with ARCCA, including proposed retainer agreements, intention to compensate, and collaboration relative to questions and answers at trial. Rather, the questions posited by the defense during voir dire testimony and trial testimony created impressions that were clearly not consistent with the actual relationship between the parties. The voir dire was necessarily insufficient and fruitless. That's on Lally. He had the opportunity to ask whatever he wanted.
Plus, it's just not true, although she seemed to be buying into it.
All right, you can read this. You got that footnote?
Yeah. To this day, the correspondence between the defense and ARCCA witnesses is missing context. No discovery has been forthcoming since February 13th, 2025. Notably, during the pendency of this case, this is the only time the defense produced reciprocal discovery prior to a discovery deadline, which doesn't kick in until you sign your certificate, which you signed your certificate without producing all of the discovery in the first place. So, what
Yeah,
about that?
Brennan. Third, the ARCCA witnesses have a clear bias in the case. In addition to the shifty trial testimony relative to the
Oh
witnesses'
my
relationship
gosh.
with the defense, the ARCCA witnesses did not contain their opinions to the parameters of their report during trial testimony. At trial, Dr. Wolf and Dr. Rensler posing as neutral. Wow, this guy, independent, like he's literally like absolutely libeling them. Posing as neutral, independent experts were permitted to speculate and render opinions far beyond what was stated in their written reports. It is still unexplained why Dr. Rensler disclosed for the first time in cross-examination that he learned of additional evidence that was favorable to the Commonwealth. Evidence that the victim was not wearing a jacket. The victim's DNA was located on the defendant's taillight. The victim's DNA was on a drinking glass near his body, and that microscopic pieces of taillight were recovered in the victim's clothes.
None
the
of
trial
which
transcript.
changed the man's opinion.
None of it.
Thank
So Dr.
you.
Rensler, Dr. Rensler alluded to the details of those findings, suggestive that had he been provided the actual crime laboratory reports or information not publicly revealed from either the defense or from the U.S. Attorney's Office, footnote.
So he's quoting his testimony from the transcript. I believe DNA was tested and some DNA was found. I believe a small amount. I don't believe any blood evidence was located or found on any pieces, but there was indication of DNA on the taillight housing. Notably, prior to Dr. Rensler's testimony, the Commonwealth was not notified of additional material reviewed or considered by either ARCCA witness. Additionally, the defense has produced no reciprocal discovery about their communication with Dr. Rensler.
Oh, that's 5. Sorry. Okay. These materials are not listed, are not in the list of materials reviewed, proffered in the ARCCA report. It's unknown the source of these materials.
I just want to interject right here. Isn't this a motion about whether or not that the jury should be told who they were hired by? When is he going to write one word relevant to the issue before the court?
Wait, he's very busy saying things. He's very, very busy just saying things. Just wait for it. I'm sure he'll get there.
It's whether or not they want to be completely neutral and independent is completely separate from who hired them. Although it also happens to make them seem more neutral and independent. But
it's very important for Hank to just say things. Just understand that. So it is disingenuous, speaking of the devil, for the defense to posture the ARCCA witnesses as completely neutral and independent. Since the February 18th, 2025 hearing date, the Commonwealth has learned that the defense-ARCCA relationship appears cozier than once portrayed. Footnote 5.
Notably, photographs have recently been discovered by the Commonwealth and subsequently produced in discovery depicting Dr. Rensler attending a private luncheon and conversing with the defendant's father at this luncheon.
Okay, so that was in the basement of wherever they were holed up, like during breaks at trial.
I mean,
that's it. It wasn't a luncheon.
I'm sorry.
It was them on a lunch break during the trial.
I bet you, though, we could find many luncheons where the police and the state's attorney talk to each other, and lab techs talk to the state's attorney, and former FBI agents talk to a state's attorney. I don't know.
There
what
is
the hell
nothing
he's getting
untoward
at.
about you eating any kind of meal with anybody who's testifying in your case, as long as they're not on the witness stand at the time that you're dining with them and you're sitting there talking about their testimony.
And guess what? Their opinion predated it.
Predated.
So what in the hell is your point, Brennan? Go ahead.
Hey, listen.
Cross-examine him about it.
Listen, Hank needs to just say things. Very important to him. So fourth, posturing that the ARCCA experts were retained by the U.S. Attorney's Office and introducing a federal investigation to the jury implies some speculation of wrongdoing attributed to investigators and or civilian witnesses. Introduction of a federal investigation. Here, you're getting your argument, babe. Introduction of a federal investigation would in turn demand a complete and transparent portrait. The introduction of the federal investigation to the jury is only balanced if the jury is fully informed about the actual relationship between the defense and the prior administration of the U.S. Attorney's Office. Any impact the defense's contribution of materials to the U.S. Attorney's Office impacted the scope and direction guiding the ARCCA investigation, complete discovery, revealing the entire relationship between ARCCA and the defense, and the conclusion to the United States Attorney's Office engaged in that comprehensive investigation, and that its investigation is now closed.
So that's that's what they want. I mean, give them some of it. It doesn't change anything.
It changes nothing because at the end of the day, what they're going to say is, you know what? We didn't know anything about your case when we did this, other than the fact that we were given a job and said, hey, this is what we're giving you. Tell us if this dude's injuries were sustained from that vehicle, or was the damage to that vehicle sustained from that man's body. That's it.
Oh, this next sentence really gets me. This next sentence really gets me.
Ooh.
Oh my God, what a joke.
Also, the jury should be informed that the now closed federal investigation had no target, led to no indictments, no criminal complaints, no charges,
but
no other adverse finding,
and
instead impliedly absolved the witnesses of any wrongdoing.
What in the hell is he talking about?
Wow.
How in the hell? First of all, they were investigating whether the police did something wrong. That's am I wrong? They were not investigating anybody inside that house, or am I wrong?
No, I mean, they weren't. At some point it bled into that in terms of at least them getting phones and getting phone records, because at some point they're like, all right, we know what happened in Birchmore. This is the same department, and we think we need to take a look at it. We're going to see if there was some kind of frame job that was going on here. So, yeah, I mean, I think they definitely were looking. We know that they were looking at the Higgins text. That's how they got all the text messages from, Higgins, Karen, all that shit. So, because of the complexity of the defense request and the fact that information necessary to create a full picture is both missing, and would lead to a trial within a trial, the Commonwealth objects to the defense motion and requests the motion to be denied.
So he ignored all the constitutional arguments. He literally wrote nothing that opposed the legal arguments, the well-founded, well-documented, rational, reasonable, legal arguments the defense put forward, and he countered not one of them. Not one of them. Just said a bunch of shit.
Very, very important for Hank Brennan to say shit. Okay. This is your motion. So, which is very unlike me. I am willing, because this is 5 pages of a Daubert Lanigan tutorial, which
has no relevance
in the read. It's not even relevant to this motion. It's like this is like a 403 thing. This is is it more prejudicial than probative? Not to me. I don't even know. All right, so you ready?
Do you want me to read it? Is that what you're saying?
Oh yeah, you're reading it. It's your
Commonwealth's opposition.
Well, what I'm saying is, you tell me skippage, and I'll fly down. Because really, the first 5 pages are all.
Yeah, no, we're gonna the commission, the Commonwealth's opposition to the defendant's motion in Limine to exclude the testimony of Commonwealth witness. Wait, Doctor, can't see it. You moved up.
What? Huh? Oh, Judson Welcher.
MS, PhD.
It's a family name, Judson.
And request for voir dire. Now comes the Commonwealth respectfully requests this honorable court deny the defendant's motion without a hearing but he wants voir dire. A witness may testify to a matter which they have personal knowledge. Rules of Evidence 602. The witness must be competent. 601. To be competent, the witness must have a general ability or capacity to observe, remember, and give expression to that which he or she has seen, heard, or experienced. In addition to the ability to tell the truth. Again, Rule 601. Credibility is resolved by the trier of fact. That would be the jury here. Rule, again, 601. Where scientific, technical, or other specialized knowledge will assist the jury in understanding the evidence or determine a fact and issue, a witness qualified by knowledge, skill, experience, training, or education may offer an opinion if his testimony is based upon sufficient facts or data. The testimony is the product of reliable principles and methods. And
sorry. Hello?
Sorry, I lost my place. And the witness has applied those principles and methods reliably. That's Rule of Evidence 702. An expert opinion is therefore divorced from the personal knowledge of a competent witness. So then he goes through the standard in admitting an expert and determining whether an expert's testimony is reliable. That's they're again where they're talking about Daubert, they're talking about Fry, and the state's equivalent Lanigan. I think you can skip all of this.
Skippage.
And then I'll just read this. Expert testimony on scientific or specialized theory is needed if the subject of expert testimony is beyond the common knowledge of the lay juror. If jurors can evaluate an expert's opinion with common sense and experience, and they can understand the underlying methods and theories of the testimony, then the expert's qualifications and the logical basis of that testimony can be effectively tested through cross-examination and rebuttal evidence. So yeah, just scroll down until he starts actually talking about this case.
Oh, that's a while. That takes a little bit. We're still going. He's still
Okay, here we go. Despite the defendant's assertion to the contrary.
This is where it gets real tasty too, by the way.
In a seemingly endless echo chamber of disinformation. Okay, I'm going to say this again because I scoffed when I read it the first time. And I did exactly that.
The seemingly endless echo chamber of disinformation is pertaining to the Commonwealth produced to the defendant. Like he's trying to say that the defendant's assertion to the contrary, he's trying to apply a seat which he is saying, which is a seemingly endless echo chamber of disinformation. He screwed it up. It doesn't read that way. Read it again. You told me.
Despite the defendant's assertions to the contrary, in a seemingly endless echo chamber of disinformation, the Commonwealth produced to the defendant not only a copy of Dr. Welcher's detailed report regarding his opinion. Why is there a semicolon there?
I don't know, but what I'm trying to tell you is the Commonwealth produced to the defendant not only a copy of Welcher's detailed report or Welcher's detailed report, that is what is seemingly an endless echo chamber of disinformation.
Right.
Not the defendant's assertions to the contrary.
Right.
I'm just telling you, it doesn't read.
He's got it, yeah. But also the extensive list of materials he reviewed in formulating said opinion, copies of those materials reviewed, 352 pages, a copy of his PowerPoint presentation related to those materials and his report, a link to a download of raw micro SD card of those materials, and a link to the entirety of Dr. Welcher's case file. See Notice of Discovery 57, items 6, 7, 8, 9, and 13. Notice of Discovery 58, items 13 and 14. Furthermore, Dr. Welcher's report lists.
Well, I think Welcher's report. Welch's grape juice.
Welcher's report lists over the first 7.5 pages the specific material he reviewed in coming to his opinion. The report further enumerates 11 items of additional information obtained by Dr. Welcher to assist in his analysis. Dr. Welcher's narrative section of his report details within the body of the report where the 140-slide PowerPoint presentation he elucidates with demonstrative evidence to support his opinions in direct contrast to the defendant's characterization of the doctor's report as virtually unintelligible. I think what you just said is unintelligible. I don't even know what is all this. In addition, the portion of Dr. Welcher's presentation of which the defendant seemingly most prominently complains, the paint testing, does not solely include a, quote, mix of images, as the defendant suggests. The presentation includes photographic memorization of the testing in question, but also slides with video memorialization of the testing and its outcome, which clearly and unequivocally, so you say, sir, support Dr. Welcher's opinion that, quote, the location and orientation of the lacerations on John O'Keefe's right forearm are consistent with the geometry and orientation of the right tail light of Reed's 2021 Lexus. Oh, please. Oh, please.
So he's going to put
We have
Welcher
eyes,
on
sir.
right after Trooper Paul. Is
We
that
all
the
have
way
eyes,
this is
sir.
going on? Oh, man.
He
All
should
right.
follow Trooper Paul.
I mean, it makes the most sense.
Notably, the defense has not challenged Dr. Welcher's qualifications to offer biochemical expert opinion testimony and concedes that a biomechanical engineer is qualified to testify as to the general principles of biomechanics, citing some cases, including one that establishes that a biomechanic is an expert opinion, the admissibility of such an opinion. Rather, the defense challenges only whether Dr. Welcher is qualified to testify to medical causation of the injuries, an opinion he has not proffered. I mean, that's basically his whole point, is this part right here.
Right.
But he doesn't even. Okay, so then he quotes this Bellwood case from 2000, a Sixth Circuit federal case. Biomechanics are qualified to determine what injury causation forces are in general and can tell how a hypothetical person's body will respond to those forces, but are not qualified to render medical opinions regarding the precise cause of a specific injury. I'm sorry. Did he not just, isn't that what you just said your guy's about to do? He's about to say how all those, the injuries line up with the
location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry
and orientation of the right tail light.
Okay,
Yeah, that's
so
exactly
you
what he
use
said.
different words to say, quote, an opinion regarding the precise cause of a specific
Hank Brennan
injury.
likes to say shit. He just comes into court,
I
says
mean,
some shit.
does anyone else think that what he just wrote there is something different than an opinion regarding the precise cause of a specific injury? Yeah. Dr. Welcher's
Well done, Mandy. Mandy came through with the perfectly timed crickets.
Dr. Welcher's biomechanical engineering opinions involve the application of classic engineering mechanics theory. Can you tell us what that is, sir?
No.
He provides
he cannot. He will not.
A biomechanical causation analysis, which employs objective biomechanical data and analysis to determine whether the forces result.
In this sentence, I'm going to use biomechanical a bunch of times, so it sounds like I'm talking about what it is. That's what I'm going to do.
To determine whether the forces resulting from a particular event are consistent with the sustained pathological condition. Okay, so you're talking about a medical condition there, right? I mean, that's what you said. Or clinically diagnosed symptom. Or in this particular case, the biomechanical causation of the lacerations on the victim's forearm being consistent with the 2021 Lexus taillight. All right, so again, you just said the precise injury was caused by a precise mechanism. All right, striking the victim. Okay, so where did it strike? What was the injury? The precise injury? It struck the
laceration. It caused the lacerations on the victim's forearm.
It struck the victim and the victim's head hitting the ground.
Yet miraculously, those huge gaping wounds on his arm, there were no tears in either of the shirts that he had on. Like it's a miracle.
No,
It's
there
like
were
a
some tears in
miracle
the
injury.
shirt.
What?
There were tears in the shirt.
There were?
Yeah.
I thought there were tears like here, like when they were cutting the shirt open.
No, there were some tears in the. I
Oh,
think.
uh-oh.
I don't know.
Somebody show me. Somebody lead me to that thing.
I don't know. Now I don't know.
You text Melanie if there were tears in the arm, because that's all we care about.
Okay. Let me just finish reading this.
I mean, because that's a lot of tears.
Yeah.
That's a shredded sleeve.
All right. June 19th, 2008, case that they're citing, a federal case. No, Wyoming, maybe state case. I can't tell. No, that's a federal case. Expert in biomechanics may testify to matters in the respective areas of expertise, including the forces involved in a low-speed accident and how those forces may affect an individual or an object. Experts may not express opinions regarding whether victims suffered a brain injury or the cause of the alleged brain
We have
injury.
our answer now. I remember you have punctate. There were punctate holes.
Okay, let's
which
just
were
substitute.
super small. They look like, that was like the thing. Are they dog teeth? Could they
Right.
be dog teeth?
Okay,
These
but
were not
let's just
tears.
okay. Well, let's just substitute this sentence with this. Experts stay. Don't. Experts may not
Sorry.
express any opinion regarding whether the victim suffered a laceration or the cause of the alleged laceration. So he's just citing cases that disprove his position, contrary to his entire position, but whatever.
Everything that guy just says bullshit.
Exactly, Mandy. Dr. Welcher is very clear in his extensive report as to what type of analysis, opinions, and the basis for said opinions are. Dr. Welcher states, as a biomechanical engineer, I have no opinion as to any aspect of his medical treatment or medical diagnosis. I've conducted an accident reconstruction and biomechanical engineering analysis of this matter. Well, just because he says it doesn't mean you're not trying to do it. Dr. Welcher then, and throughout the body of his report, made specific reference to 2 pages of specifically enumerated references within his field of expertise that he reviewed in arriving at his opinions. Situated between the classic disciplines of engineering and medicine, biomechanics provides a means of applying engineering mechanics theory to a problem of an accident. Injury causation analysis is a multidisciplined endeavor that employs objective medical and biomechanical data and analysis to determine whether a motor vehicle crash caused a pathological condition or symptom diagnosed clinically. And that's Welcher's report, again, talking about what the mechanism caused what specific injury. Okay. His credentials and expertise within the field are profound and extensive. They're profound.
Extensive.
Profound. Wow.
And extensive.
The defendant has been appropriately noticed of Dr. Welcher's expertise, his opinions, and his extensive materials he reviewed in formulating said opinions. Dr. Welcher's methodology, detailed profusely within both his report and associated PowerPoint presentation, photographs, and videos, is well-founded in his discipline, and his expertise within this discipline is unassailable.
Unassailable.
Dr. Welcher's qualification in the field of crash reconstruction and biomechanical engineering are beyond reproach. Beyond reproach.
Isn't this the same guy who said that what's his nut was very honorable? the cop, whatever his name is, they'll know
Proctor?
in the chat. No, not Proctor, the other guy.
Dr. Welcher's testimony should not be misconstrued as a medical opinion. That misses the point and exaggerates the extent to which this witness would be testifying to observations within his area of expertise. The Commonwealth has demonstrated that Dr. Welcher's testimony and opinions are amply based on reliable biomechanical methods and testing that is generally accepted within the relevant scientific community, and will assist the jury in this case, citing a case. Therefore, no hearing or voir dire is necessary, and Dr. Welcher should be permitted to render his expert opinion in biomechanics. Not sworn.
Oh, not even
Not even
sworn.
No.
Even sworn and subscribed to. Wow.
Nope.
All right.
Just some words on a piece of
We're-
paper.
So just a big 7 pages of words.
And none of what he's put in the parts that we skipped. Just scroll down. What you would have
what?
liked to see is like one example of where he says that somebody, well, I mean, they'll just take our word for it anyway. Where a biomechanical expert testified to something remotely similar as he's trying to get this expert to testify. Where's one case that says that? Just one.
I mean,
I
I'm
mean,
Hank Brennan and like to say shit. I'm Hank Brennan and like to say shit. I mean, he just says shit. It's crazy. I've never seen anything like it. I mean, this dude never comes with receipts. He just says shit. All right. Okay, so we've gone through Easter, right? We did Easter. I think all that's left. So I think that at the very least that they're going to have a voir dire of that guy.
I don't even know why they would need to, because he's not allowed to express a
Well,
medical opinion.
I know, but Alessi wanted to keep him out on the papers. The papers. You know, he said, well, in the alternative, let's have a hearing, you know.
Well, right.
So let's see. Yeah, I don't think this had.
Oh, so they were just trying to keep out the photographs related to that. The photographs.
Right, which I'm assuming is the 140 page or slideshow. All right, so this is the buffer thing. Like, how much of this do you want to go into? It's just him sniveling.
Nothing, no. I mean, I don't know. Ask the people, I guess.
What do you? I mean, you guys.
Commonwealth requests that the court again order that individuals are not permitted to wear or exhibit any buttons, photographs, clothing, or insignia relating to this case or any trial participant in the courthouse during the retrial. That's what he's asking for.
Well, no, the buffer zone is outside. The outside of the courthouse. He's like, so to prevent this from reoccurring, because he said that there were demonstrations and people wearing clothes and buttons. To prevent this from reoccurring, the Commonwealth requested a buffer zone be extended to include the area encompassed within Bates Court, Bullard Street, Ames Street, and Court Street. So then he gives the background. He's talking about the ACLU of Mass sought leave to file an amicus or amicus, depending on how you pronounce it. I say amicus. You say tomato. I say tomato. You say potato. I say potato. So following a hearing on April 4th, the court denied the motion to intervene, granted the ACLU of Massachusetts leave to submit a memo, and ordered that no individual may demonstrate in any manner, including carrying signs or placards within 200 feet of the courthouse complex during trial of this case, unless otherwise ordered by this court. This complex includes the Norfolk Superior Courthouse, buildings in the parking area behind the Norfolk County Registry of Deeds building. Individuals also prohibited from using audio enhancing devices while.
All right, but what's more interesting about
bullhorn.
this is that the ACLU filed the petition. She didn't give them even leave to intervene. And then they filed to the Supreme Judicial Court. And then a second petition was filed. Scroll down. Individuals who wish to demonstrate. Wait, stop. What?
Where?
At the beginning?
Here?
Oh, no, just go to the top of the page.
Here? Wait, the top of this page?
No, babe. Jesus.
Here? I was there.
The Commonwealth opposed the petitions. The defendant again took no action. So the Supreme Court denied the petition, and they held that the denial of the motion to intervene was an ordinary procedural ruling, and that they couldn't use their extraordinary intervention, and they denied any relief. So,
how does this? So it goes on further to say that the single justice also determined on the merits that the buffer zone ordered past constitutional muster. How is this not prior restraint? Can you explain it to me? How is this? This is literally what prior restraint is. Prior restraint.
Right, but as long as there's a rational basis, like a rational basis of protecting a greater good. So it's got to be rationally related to that.
A 200-yard buffer zone around a courthouse? How is that rational? Like it flies in the face of free speech and the ability of American citizens to be able to demonstrate.
Well, I mean, maybe it
mean,
should have been during time frames. They don't want the jury to be able to hear anybody, which you wouldn't want if they were out there screaming, "Kill Karen Reed."
True.
We'd be,
I'm like, hey,
so-
can we get rid of the people screaming, "Kill Karen Reed" out there, Judge? Thank you.
Right.
She'd say, "Now, you know what?
Karen Reed's a
America.
murderer. Kill
America.
Karen Reed. Right.
America. Are you asking me to infringe upon their ability to have free speech? Is that what you're saying?" So the single justice also determined blah blah blah. Oh, so specifically the establishment of the buffer zone was content neutral. And read it's because there was nobody content neutral. It's because there was no one on the government side out there protesting. There were like 2 people.
No, they were saying like the buffer zone wasn't limited to the words they were speaking. That's why it was
That's
content
what I mean.
neutral.
It wasn't content neutral because everybody out there was free Karen readers.
I understand, but they just mean that the judge's order was content. It didn't matter what they were saying. It applied to everybody.
Yeah, but in practice,
I
it
understand.
only applied to free Karen readers because there were no government lackeys out there.
I understand, but we're talking a constitutional, argument here.
I
So
find it to be a constitutional violation. Sorry. The petitioners appealed 200 yards. Do you know how big 200 yards is? It's 2 football fields. 600 feet. It's like it's outrageous. The petitioners appealed the single justice's judgment to the full Supreme Judicial Court.
they also found that it was narrowly tailored to serve a significant government interest, left open ample alternative means of communication. So, I don't know why he wasted so much time, like, focusing on this.
I know, because she's clearly going to do it again. Like, there's not a chance she's not doing it again. If anybody thinks the buffer zone's not going to be there, it's going to be there. I mean, she's not even letting like anybody that's not actual media, real media, actual media is the only people that can be in there with the press.
But he's looking to expand it, so that's what we're going to see. Does she expand it?
Boots on the ground ain't backing down. Honk for justice. Morrissey and McAlbert, federal prison 2025. It's America, baby. It's America. So in addition, it's America.
This is a part she's going to find most offensive right there.
So in addition, at the beginning,
right there, yep.
In addition, as the court found when it issued the buffer zone order, protesters have shouted at witnesses and have confronted family members of the victim. Witness intimidation also remains a prevalent issue in the case, with additional criminal charges having been filed earlier this month. See Commonwealth v. Aiden Carney. So see also the affidavit of Juror Doe, describing efforts by individuals to intimidate, harass, and dox jurors following declaration of mistrial. The reestablished, is that affidavit attached to this? The reestablishment of a buffer zone is therefore necessary to help ensure that both parties receive a fair trial. There again, Commonwealth and their right to a fair trial, free from outside influences.
So keep scrolling, they're talking about the 200-foot buffer zone.
Okay.
Keep going.
Oh, big picture.
All right, hold on. During deliberations, we could hear protesters outside screaming and yelling. Another consequence of the 200-foot buffer zone, individuals positioned in these areas were close enough to Court and Ames streets to encourage passenger and commercial vehicles traveling on those streets to honk their horns. That I don't see how that is affecting a jury. They don't know which it is for.
Honking, no honking.
Talking about how that happened repeatedly. So scroll down. So he's asking to maintain the jurisdiction the integrity that it go up to 400 feet. That approximately 300 feet
allowed to drive during the entire trial in the entire county. No driving. That's what the new rule is going to be.
The extended buffer zone would range from approximately 300 feet between the north side end of the complex and Bullard Street to roughly 400 feet between the complex and Bullard Street. This would bring the buffer zone to those areas where demonstrations undermined the buffer zone's very purpose, while at the same time ensuring that demonstrations are not moved any further away from the courthouse complex than is necessary to prevent those same issues from reoccurring. He's arguing that those are narrowly tailored and that it falls within the constitutional, limitations that the court
Slips right under
recognizes
prior
those around.
restraint. Slips right under prior restraint. Whew, right under.
I don't think honk for justice is an issue. They don't know if they're honking for which justice they're honking for.
What about the sirens that were constantly going off every time the cops told a lie? It was
Because
like,
they do
an
the
angel
same
gets their
thing.
wings every time a bell rings. It was the same shit. Every time a cop lies, the sirens fly.
But they do the same thing. That honk for justice, just switch it around and take it to a place where it's people who are hoping that a defendant gets convicted. They're also screaming to honk for justice. So how does a honk matter? Doesn't it really doesn't matter. It could actually be detrimental to Karen Reed because the jury could think they're honking to convict Karen Reed.
Right. Honk if you think she's guilty. They don't know. They don't know.
And I don't think the defense really has a dog in the fight. I don't know. They haven't really they didn't oppose it before. So prior restraint is when the court says, when there's an order that prevents you from saying
Or law, any government law.
any law or order or anything that prevents you from speaking out, from your
Violate your
freedom of
absolute
speech.
First Amendment right of freedom of speech.
And the ability to protest, to have demonstrations, and to speak. So a prior restraint is a restraint on that, something that limits that. And there's certain things that they have to show. They have to show that it's reasonably necessary to solve some sort of greater good, that it's been narrowly tailored to achieve the purpose, that it doesn't over limit freedom of speech, freedom of association, all of that.
And if you're new to our chat or to our show, like I say this all the time to our people, because I think people kind of don't either understand or they don't know or they forget that the Constitution was written for us, the people, the citizens, to tell the government what they cannot do to us. It's not the other way around. Our rights are enumerated in there, and it tells the government you can't do X, Y, and Z. If you do any of those things, you're violating our rights under the Constitution. So just always remember that. That's your baseline when you're thinking about constitutional law or the Constitution of the United States. That's why we love due process here. We are the due process gang. Mandy's got some great designs coming up for some t-shirts, and they better
Proud member.
So what about this? Anything else?
No, I don't think we need it.
Okay.
You could go, then that's the end.
Well, at least he put a certificate of service on this one, at least.
But not, it's not any sort of sworn, the facts that I'm giving in here are true and correct and accurately.
All right. So, I mean, look, she's going to grant the buffer. She's going to allow ARCCA in. I still think she's going to deny.
Is she going to extend the buffer? That's the question. We shall see.
We shall see. We shall see. And, obviously we've got this, we're waiting for a decision on the motion to dismiss. Like I've said, like both sides have to proceed as if it's not going to be granted. Like they can't sit around, resting on their laurels, like thinking this thing's not going to trial.
Right. And the state's making two arguments out of their asshole. Like Idiot Wind points out that Brennan's trying to have Welcher testify, but not Rentschler,
right?
And Kasha's 16 months. Holy moly! I'm a Defense Diaries toddler. Thanks for the knowledge.
Too much prosecutors.
16 months old. Karen confirmed today that Bob Alessi doesn't sleep. He's a freaking vampire.
He's a vampire.
Generosity. Kim says I should not try to comment from my phone with no glasses. Oh, that must be from an earlier an earlier comment, but thanks for, oh, we're going to get to it, but thanks for your generosity. Idiot Wind again says church that gave them space to have lunch during trial to avoid whatever that throngs. But that's what Bob was talking about earlier, that the whole, oh, there's a photograph of him talking to of ARCCA witness talking to Karen Reed's father. This is in,
what did he call it? He called it like a reception or a luncheon.
A luncheon.
They were having a luncheon.
They were having a luncheon in the space that a church gave them to have lunch during trial. Kim says people keep saying Hank Brennan's motion ate CARSP, but he's not wrong for legal wins. He's wrong for Bev to give her a reason to agree with him. It doesn't take much. She bends to help him. I mean, we'll see it. And I guess like I am.
So now you know why Kim sent this.
Right.
You should not try to comment from my phone with no glasses, because she had a couple of typos in there.
Right. And as Josh pointed out, most of those.
I think what Kim was trying to say is our crap. That's what my guess is.
Right.
People keep saying Hank Brennan's motions are crap.
Right.
I agree. I agree. Like
yeah.
like what she's saying, she's just, he's saying shit so Judge
he
Cannone
knows
has
what he
something
can,
to hang
he
her
knows
hat
right. He knows what gets Judge Bev going.
Right. 100%.
You know? And as Josh pointed out, the motions allege facts with no affidavits. And cool lady, almost a year.
Family hugs.
Yeah,
All right, so I've got to run off to.
Thanks, Melissa.
I'm assistant coaching Scarlet's softball team, so we've got to. That's at 6. So tomorrow we're covering it. We know Mel's covering it. We know Andrea's. We know there's a ton of stuff. Pop around. Come and hang out with us. We all have different insights. We are the only ones that have puppets. That's all I'll say. I'll leave it at that. No, but we'd love to have you guys over here. We thank you guys for hanging with us tonight. Mods, you're beautiful. I think our coverage starts at 8:00 Central Daylight Time. So boom. But yeah, pop around. We love Melanie. We know you guys have lots of choices, but we'd love to see you hang with us a bit too. And again, thank you, mods. Thank you guys for all your generous support. We will see you bright and early tomorrow morning for a whole bunch of Karen Reed stuff. And we hope you're there, because without you guys, I'm just an old man
sitting around talking to his wife.